Welcome to Oil and Gas Law with Energy Law Prof. Today we're going to talk about conveying minerals versus conveying royalties. And we'll see that it is sometimes difficult to interpret exactly what parties were intending to convey in terms of a mineral interest, in terms of a royalty interest. So we will start with a little bit of a reminder of the kinds of royalty interests that we've talked about. One is the lessor's royalty. That's what we've most commonly talked about. That's what the lessor, the landowner, reserves from the lease. And so the oil and gas company gets to keep the rest, maybe 7/8. The landowner gets the lessor's royalty, maybe 1/8. Then we've talked about an overriding royalty. So that is granted from that leasehold interest by the lessee, by the oil and gas company. So the lessee might say, I will give 1/16 to another oil and gas company that's willing to do some exploration for oil and gas here, to drill a well for me, etc., to frack the well for me. So that's granted from the oil and gas company's leasehold interest. Okay, finally, non-participating royalty interest. That is created by a mineral owner to burden the mineral interest. It's not connected to any lease. It's non-participating in any lease. It's created by the landowner. So the landowner could have sold a 1/16 interest in production on his or her land to somebody else. Maybe the previous landowner, when he or she sold the land, reserved for him or herself that 1/16 interest. So it can appear in a lot of different ways. But what we'll see, it's often important to determine is this a royalty like the one that we saw in that earlier Govenda case, if you remember, where it simply says, I want a fractional interest, 1/2 of production, 1/16 of production, 1/100th of production? Or is it going to be a fraction of whatever the lease royalty is? So 1/2 of the lease royalty, 1/16 of the lease royalty, 1/100th of the lease royalty. And so you can see with that non-participating royalty interest, although it's created between two landowners, so it's not connected with a lease, the value of it can be determined by how big the lease is, because it could be something like 1/2 of any present or future lease royalty, in which case it's 1/2 of that 1/8 royalty, or that 1/4 royalty, or whatever the landowner subsequently negotiates. Okay, so when we're considering whether something is a mineral interest or a royalty, we're going to be taking the usual interpretive steps that we take when interpreting a legal contract or deed, any kind of writing. So first we're going to look at what's the plain meaning, looking at the four corners of the instrument. Then we're going to talk about rules of construction. If there's an ambiguity, when just looking at the plain meaning, we start using rules like the largest or greatest possible estate. We start interpreting against the drafter. We maybe look at specific things rather than general things. Maybe we focus on what's handwritten that seems to have altered the contract. And then if all those things fail, right, there's no plain meaning that we can figure out, it's ambiguous, the rules of construction cut both ways, then we can maybe look for extrinsic evidence, but that's very rare. So generally the courts are going to try and focus on the document as written and figure out what its intent is. All right, we're going to start talking about this issue of determining whether something's a mineral interest or a royalty by looking at this quite complex case, McSwine versus Musselshell County. It's on page 432 in your books, and it's a Montana case. So in this case, there are actually 3 writings that describe what was retained, reserved by Musselshell County when they transferred land. So there was a 1933 contract that says the county reserves to itself and its successors an undivided 2.5% of all oil, gas, and other minerals lying in, under, and beneath the premises. There's later a 1943 decree that has pretty similar language. It says, and this was as a result of the consent decree, Shield says, I own the following real property, accepting and reserving to the said defendant, Musselshell County, 2.5% of all oil, gas, or other minerals lying in, under, and beneath said land. Okay, we're going to get really good at determining whether something is a royalty interest or a mineral interest over the course of today's lesson, but I want you to look at that And just as a preliminary matter, tell me, is this a mineral interest or a royalty interest? And what we'll see is that this is language, these first two have language that sounds like a mineral interest because it says, line in and under, right? This is describing the oil and gas as it's situated in the ground, not, which is the mineral interest, that oil and gas in place in the ground. It is not describing the oil and gas that comes out of the well. And that's really the touchstone, right? Is this describing oil and gas where it's sitting in the ground or the oil and gas that comes out of the well? Okay, now that's interesting because if we look at the third way this land was described, it's different. So in a 1944 deed, what the Musselshell County said is, we're reserving an undivided 2.5% royalty of all oil, gas, and other minerals lying in and that may be produced from the premises. And so later we'll see that if it says produced, that sounds more like a royalty, and here it actually uses the word royalty and says that this is a 2.5% royalty, whereas previously it had said it was 2.5% of what was lying in and under, and that is typical mineral interest language. Now, we'll consider the importance as we think about this case of that distinction between a royalty interest and a mineral interest. So, 30 years pass from that initial sale, right? Those were in the 40s. Now we're in 1981. In 1974, Shields leases to Exeter. So the owner of this, not the county, the owner of everything else, leases to Exeter. The county issues an oil and gas lease to McSwine. But when it does that, it says, we reserve the right to contend that our interest in this land is a royalty. Okay, what's going on here? First of all, can you lease a royalty? No, you can't. We've talked about that already. We'll talk about that more in the future. Royalty is a share of oil and gas production. That doesn't give you the right to lease the property. You can only lease the property if you have a mineral interest. So when the county leases the property to McSwine, presumably they're thinking, okay, I think what we have is a mineral interest, but I want to be able to continue to argue that what we have is a royalty. All right. So McSwine says, okay, so the county won't even really tell me whether it has a mineral interest or a royalty. So I'm going to bring this action that we're currently reading to determine whether that lease is valid. And then what royalties I would owe. Okay. So the district court says, look, a mineral interest is more valuable than a royalty because it can be leased. As we discussed, a royalty cannot be leased. That's just a share of production. And it relies on this underlying Montana rule, which says that the state can't give away something without receiving compensation. Basically, this is supposed to protect public lands, public welfare. They can't just give away the value of that mineral interest without anything in return. And so even if the first two descriptions of the document described it as a mineral interest, then it can't turn around and say, actually, never mind, you go ahead and keep the full mineral interest. All I want is a royalty. That would be an unconstitutional giveaway because according to the district court, that mineral interest is more valuable because it can be leased. All right. We'll talk more about leasing fractional mineral interest in the future, but let's just say that the district court is correct that mineral interest can be leased even if you have a small mineral interest. How big was it in this case? 2.5%, right? Just a 1/40th mineral interest. So yes, it can be leased. That's correct. And it's also correct that the royalty can't be leased. But is the mineral interest really more valuable? Well, let's think about that a little bit more. So the conclusion of that district court is that therefore the mineral interest is valid. It's not a royalty interest. And so therefore it was okay for the county to lease it to McSwine. The leases are valid. Now, time it gets to the Supreme Court, they have a more subtle analysis. And it's really important that you understand what they're saying here. The court says, wait a second. A mineral interest has different rights than a royalty. But a royalty interest, in fact, can be much, much more valuable. Okay, why is that? Let's think about that. So remember, this is a 2.5% interest. That's 1/40th. Okay, if you prefer to deal in fractions. So let's think about what a 1/40th mineral interest. Okay, so we have a 1/40th mineral interest, and we compare that to a 1/40th royalty. Okay. Now, what I want you to think about as you think about that is which of these is going to be bigger. So the mineral interest, if you leased it, what would you receive? If they leased it to McSwine, what would they get? Well, what do you usually get for a mineral interest? What you usually get is a royalty. So they get a 1/8 royalty normally. Maybe they could negotiate a little better, but that would be 1/8 of their only 1/40th of the minerals under the ground. And so they would be likely to receive a 1/320th royalty. Okay? So think about how much smaller that is than the 1/40th royalty that was received, would be received under the alternate interpretation that you get the royalty. Now, it's true, as the mineral interest holder, you get some other rights. You have the right to negotiate a lease, which you can't, there's nothing to negotiate if you're owed a royalty. You would also get 1/40th of the bonus, 1/40th of the delay rentals, all those rights under the lease that you get from leasing your mineral interest. And so you get some other small benefits. But at a basic level, a 1/40th mineral interest is going to get you, of the oil that comes out of the ground, basically 1/8 of 1/40th, right? Whereas the royalty, a 1/40th royalty, is getting you a full 1/40th of the production. And so you might want to think about this a little bit more. It's crucial to some of the things we'll discuss in the future cases here, but it's important for you to understand that that royalty interest is likely to get about 8 times more money than that mineral interest would receive. And so the court here correctly says that that royalty interest might be much more valuable. Now, of course, the district court was correct that the mineral interest is conceptually larger, right? Because it includes that right to lease. When you lease, you get a bonus, you get delay rentals, you get 1/40th of those things. But fundamentally, you are getting just a fraction of all of those things, whereas with the royalty, you get the full 1/40th of all production that comes out of the ground. Okay, so according to the court, it says, therefore, the royalty was valid. This is a royalty. It's not a mineral interest. And because it was a royalty, the county could not lease to McSwine. Therefore, McSwine's leases are no good. Okay, now I want you to think about something that may be a little bit puzzling to you. Can you lease a 1/40th mineral interest? Well, as we'll see in a future class on co-tenants, yes, you absolutely can. And it's common that a fractional interest, a mineral interest like this, might be leased. But of course, the person who leases the vast majority of the mineral interest, the other 97.5%, is going to have more influence on how the land is developed. Okay, now it is also important to understand that other caveat that I mentioned, but it's not in the case, which is that just because you have the royalty, that's not going to get you the bonus and delay rental rights. That just gets you a share of production. So it's important to understand that there is a circumstance where you'd rather have a 1/40th mineral interest rather than a 1/40th royalty. What's that? Well, that's if it's a dry well. Because if it's a dry well, with that 1/40th mineral interest, at least you get 1/40th of the usual bonus that would be due for the whole land. So you're going to get some money at least. But with the royalty, you are not going to get anything until there's actual production from the land. Okay. Now, you might want to think, if a non-participating royalty interest holder has one of those royalties that is not just a set percentage, not just 1/40th, or not just like 1/2, like we had in the Govenda case. But what if it's that other circumstance I mentioned where that non-participating royalty interest holder says, I want 1/2 of whatever the landowner gets, 1/2 of all lease royalty. Remember, I said that's probably the most common non-participating royalty interest that you'll see. Well, that can create some complications when the landowner who actually has to lease the property makes a complicated lease. It can sometimes be hard to determine what's a royalty that has to be shared, 1/2 of it, with that non-participating royalty interest holder. So here's the example that's given in your book. Harris conveys a ranch to the Smiths, reserving 1/2 of all royalty, 1/2 of all oil royalty, gas royalty, and royalty from other minerals under the terms of any oil and gas lease. So presumably Harris is doing this because when he sells this ranch, he's thinking, what if there's a lot of oil and gas under this ranch? I didn't get paid for it. We assumed I was just selling it for agriculture. I want to make sure I'm protected if there's a lot of oil and gas development later on this ranch. So sure enough, there is oil and gas. And so the Smiths, who now have the ranch, negotiate an oil and gas lease. And here are the terms of it that are described in your book. First, there's a bonus, okay? Does that get shared with Harris? No. Harris does not get the bonus because he only gets to share 1/2 of all royalty, and a bonus is not a royalty. Okay, then there's a delay rental. Does Harris get to share 1/2 of the delay rental? No, again, that's not a royalty. All right, then there's some weird provisions, okay? 4 is pretty normal, right? 4 is just a royalty. Is that get shared with Harris? Yes, of course. He's supposed to get 1/2 of all royalty. But now let's think about some of these other provisions and whether Harris should be able to share them as, he gets his 1/2 of whatever royalty is paid. So as a reminder, he doesn't get the bonus, he doesn't get the delay rental, but he does get the royalty. Okay, now let's think about 3, 5, and 6, because they're a little bit more interesting provisions. So first, not as royalty, 2% of all production. Okay, what does that mean? Is that a royalty? It says not as royalty. So I guess it doesn't have to be shared with Harris? No, that is absolutely a royalty. If you have a constant share of production, that is a classic royalty. Remember, share production free of all costs, that's what a royalty is. So you can say, okay, that's not as royalty if you want to, but the reality is it is a royalty. And so this absolutely will be shared with Harris. And we'll talk about a case in a second that says that. Okay, now I want you to think about those other two, maybe more difficult provisions. 6% more production, so it sounds like a share of production, but only up to a fixed number, 64,000. That's interesting. Then also this sort of top up, which says if you're not giving me enough money in any given year, you have to give me at least $2,500 for that year. So interesting question. Okay. So on the question of whether that not as royalty 2% counts as a royalty, we have this case, Griffith versus Taylor, described on page 440 in your book. Here's what the Texas Supreme Court said there. It may be that the words bonus and royalty in their broadest concepts and meanings are conflicting and overlapping. On the other hand, when it's necessary that they be distinguished, there is a narrower concept of the two terms as they are ordinarily and commonly used and understood in the oil and gas industry, in which they do not conflict but are harmonious. In this narrower sense, a reservation or payment of a part or percentage of production, like that 2% of royalty, 2% of production, under a lease, which continues throughout the life of the lease, is regarded as a royalty. And a sum certain to be paid in cash or out of production is regarded as a bonus. So let's go back and look at this. So yes, according to the Texas Supreme Court, undoubtedly this not as royalty, 2% of production, that is absolutely a royalty. On the other hand, the court says a sum certain of production, like $64,000, that is to be paid out of production, like this 6% of production up to $64,000, does not count as a royalty. That's a bonus, doesn't get shared with Harris. Okay, we'll see in a future class, so there might be something wrong with this from Smith's perspective. Smiths may get in trouble for doing this, but just at the base level of is it a royalty that has to be shared with Harris? No, it does not have to be shared with Harris. Okay, then there's this other provision, a top-up of up to $2,500 a year. Is that a royalty? Well, hard to say. I mean, it's basically when there's less production, so maybe that, so the royalty didn't add up to $2,500, you have to top it up to $2,500. So if it's not a share of production, then it sounds like maybe it's not a royalty, so it doesn't have to be shared with Harris. Okay. Let's talk about this production payment for a second, where it's a 6% of production up to $64,000. This is not an unusual provision to be included in an oil and gas lease. It's not nearly as common as just this typical bonus and royalty that we've talked about. But this idea of a share of production or production revenues until a stated amount has been recovered is not that uncommon. So here's another example. For example, 1/16 of the oil and gas produced and saved until $50,000 has been received. Sometimes that's called an oil payment. Now, so because it's kind of a sum certain to be paid out of production rather than a fraction of production that will continue throughout the life of the well, it's generally treated as a bonus by the courts. You might imagine, though, what if instead of saying, up till 50,000 has been collected, what if it was up till, 50 million or 50 billion? In that circumstance, it kind of seems like you're basically just saying 1/16 of production more, in which case it starts to look like a royalty. So that principle hasn't been fully tested in the Texas courts, which is maybe an interesting hypothetical question. Okay, so we've kind of figured out overall what's shared with under this 1/2 of royalty with Harris. Well, we know not the bonus, not the delay rental. Yes, the not as royalty. Yes, the royalty. Probably not the 6% of production. Maybe not the top up to $2,500 a year. What I want you to understand from this exercise is mostly that when you have this very common non-participating royalty interest that says you get 1/2 of all the royalty, the landowner who then leases and has to share with you doesn't get to just call things not royalty when they clearly are. And so I guess, the analogy I would draw is like, you can call a Pop-Tart a sandwich here, but that doesn't make a Pop-Tart a sandwich. When people say, I want 1/2 of the royalty, they're thinking of anything that looks like a basic royalty. And so they're not going to allow the current landowner to manipulate these terms so that nothing gets shared with the non-participating royalty interest holder. Now, there's some other interesting kind of lease benefits that you see other than that typical bonus, delay rental, and royalty. One thing you sometimes see is a net profits interest, which is a percentage of the net profit, usually with no personal liability. So basically, just if you get big net profits on this lease, I want a share of it. Now, if you look theoretically at how landowners could get the most, in fact, a net profits interest might be the way that you could get the biggest benefit from oil and gas on your land. It's typically not used except by very sophisticated parties because it would require you to figure out what profits are, which means you would have to audit all the oil and gas companies' expenses. That's why generally landowners are happier with a royalty that just gets them a share of production. They don't have to worry about what the oil and gas companies' expenses are because they get the same share of production regardless of what those expenses are. But countries that are looking to maximize the value of their oil and gas and are much more sophisticated might have to look at the company's expenses anyway for purposes of taxation or otherwise, much more likely to use a net profits interest. Okay. Another interest that you sometimes see is a carried interest. So this is an interest where, again, you get a fraction of net profits, but you can say, well, you don't get to deduct all of your costs because some of your costs I don't want to audit, but go ahead and deduct the cost of drilling directly or the drilling rig, but don't charge me for overhead, office expenses, etc. All right. Another question that shows up with these non-participating royalty interest holders, what if, again, we have a non-participating royalty owner. Again, they own a fraction of royalty, like in that Harris versus Smith case. So in Andretta versus West, a Texas case from 1967, the non-participating royalty interest holder had 1/4 of royalty. So the question is, if the landowner was paid damages for the oil and gas company's failure to respect the implied covenant to prevent drainage. So the oil and gas company allowed oil to be drained from the land, and the landowner received damages for that violation of the implied covenant to prevent drainage. Does 1/4 of those damages have to be shared with a non-participating royalty interest holder? And the court says yes. So that compensatory royalty was basically a substitute for the royalty that would have been received by the landowner if production had happened on the land rather than the oil being drained off. And so 1/4 of it has to be shared with that non-participating royalty interest holder. All right, let's talk about distinguishing some more a mineral interest versus a royalty interest holder. We have this Barker versus Levy case from 1974. In this case, Levy is granted a 1/160th part of all oil, gas, petroleum, sulfur, and all other minerals that may be produced and saved from the following described lands. Okay, is this a 1/160th mineral interest or a 1/160th royalty? All right, well, the court says this is a royalty interest because it doesn't have that key language you may remember for we just talked about in that the mussel shell versus mixed wine case, which is it doesn't have that in and under language. Instead, it has this produced language. And so that produced language indicates that it is a royalty interest rather than a mineral interest. Okay, great. So common mineral interest and royalty language. Here again, mineral interest, very often going to say in, under, and that may be produced from the land. Royalty is often going to say produced and saved. Now, one thing that's a little bit confusing, both of these kinds of language have the word produced in them. Why does the mineral interest, if it's really just describing oil and gas in the ground, have that word may be produced from? Remember, that's because of the rule of capture. So if you have the oil and gas on the land, you not only have the oil and gas underneath the land, but also you can produce oil and gas from that land that draws production from your neighbor's land. And so that's why we have to include that caveat of produced from. The problem with that is that it makes these two things a little bit confusing. So I would, when you're thinking about is this a mineral interest versus a royalty interest, I would focus a little bit more on that. Does it have that in and under language, which generally marks it as a mineral interest? Now, we'll see it can get even more complicated, but I think the other thing you want to look at is that the thing you need to keep in mind is something I mentioned earlier. There's no magic language. Really, we're saying, are you describing a piece of rock or a can of oil? We're describing the oil and gas in the ground or the oil that comes out of the well. Oil and gas on the ground, that's the mineral interest. Oil coming out of the well, that's the royalty. All right. Now, there are some minority views who will, in some circumstances, interpret a royalty interest as though it's really a mineral interest. And let me explain that to you. This isn't Texas, but some other states take a different approach. So in West Virginia, maybe Alabama, Illinois, they say, look, if you've given a grant of profits, that royalty share, we have this rule that that's basically a grant of the land itself. So maybe that gives you a mineral interest. So if you have 1/2 of the oil and gas royalty, maybe that means you should get 1/2 of the bonus as well. Other states, Colorado, didn't even recognize non-participating royalty interests as valid until they were authorized by statute in 1991. As we get more into all the legal problems that non-participating royalty interests create, you may think, oh, we should have gone with the Colorado rule. And they don't even allow them. With that said, clearly they were authorized by statute for a reason, which is they're very economically useful, even if they create legal problems. Oklahoma cases are particularly confusing. So Oklahoma, remember this distinction between a 1/2 royalty, like in the Govenda case, which is very rare, and a 1/2 of royalty, which is very common. So Oklahoma tries to distinguish between these. It says it's a definite royalty if it just tells you the fraction, 1/16th royalty, 1/100th royalty, or like in the Govenda case, 1/2 royalty. And then an indefinite royalty is if it makes it dependent on what the lease will be whenever the lease is signed. So if it's 1/2 of royalty, like in that Harris versus Smith hypothetical, that's an indefinite royalty, unless the lease already is in place on the land. Because if the land is already leased, then we know, okay, 1/2 of royalty is 1/2 of 1/8, if that's the royalty, so it's 1/16. So it becomes definite as it's calculated at that time. So those Oklahoma cases tend to be confusing, but we're going to focus mostly on Texas. Okay, so if you can use the sort of basic language that shows something to be a mineral interest or a royalty, why do the cases get so confusing, as you may have noted from the reading? Okay, well, first, sometimes that grant or reservation does not make clear, doesn't use that typical language, whether it's a mineral interest or a royalty interest. Sometimes the languages are simply just mixed together. Also, a lot of times you get somebody who tries to customize an interest, have a mineral interest and take certain rights away, like the right to lease, or have a lease and add certain rights. And that can sometimes make things confusing. So let's look at a few confusing Texas cases where it's a little bit hard to tell what kind of mineral interest or royalty is intended. So first, let's look at this French versus Chevron case, page 451. Here's the language here. An undivided 50-acre interest, being an undivided 1/656 interest in all of the oil, gas, and other minerals in, under, and that may be produced from the following lands. Later it says, this conveyance is a royalty interest only, and the grantee shall never have any interest in the delay or other rentals or any revenues or monies received from the leasing or the renewal or extension of any lease, and that the grantee shall never have any control over the leasing of said lands. So what's very interesting about this, of course, is that here this has the in and under language. So that sounds exactly like a mineral interest. But then here it says this is a royalty interest only, right? So how do we reconcile these two provisions? Well, here's what the Texas Supreme Court says. The Texas Supreme Court says, okay, this is just a 165th of the lease royalty. I want you to notice, one great thing about oil and gas is because there's so much money on the line, it's amazing. People will take a 1/656 interest and litigate it all the way to the Supreme Court because that's how much the oil and gas interest can be worth. But notice here we're saying it's only 1/656 of lease royalty. So presumably if the lease royalty was 1/8, this is just 1/656 of 1/8. And what the court is effectively saying here is what happened in this deed, which kind of mixes the mineral interest language and the royalty language, is that first we granted a 1/656 mineral interest because it was in and under, but then we said, oh no, we're taking away all the other delay or other rentals to indicate that we basically created 165th of lease royalty by giving you a 1/656 mineral interest, which would come with 1/656 of lease royalty, and then stripping away the other things like the bonus and delay rentals, right? So do y'all think about that for a second. If you have a 1/656 mineral interest, right? What does that usually mean you have? Well, that means you're going to get, 1/656 of the usual lease royalty, right? Of royalty. And then you're also going to get the 1/656, right? The same thing of the bonus, right? And the you'll get 156 of the delay rentals, et cetera, et cetera. And the court is saying you just got rid of this, and all you left with is 1/656 of the lease royalty. That was intended by this deed. Okay, so this case is a little bit confusing because there's another case from the Texas Supreme Court that seemingly reaches the opposite decision, but I'm going to do my best to reconcile them. So in this case, the grantor reserved title to 1/16th interest in and to all of the oil, gas, and other minerals in and under, and that may be produced. Okay, what is that? Again, mineral interest. But then it says, without the right to lease, bonus, or rentals, and it says, and shall receive the royalty herein only from actual production. So it may sound again like kind of got that 1/16 mineral interest and then stripped everything else away. Certainly, it does have that in and under language. It makes it sound like a mineral interest. But here the court says no, it's a 1/16 royalty. Now, how can you reconcile these two cases? Well, let me be frank and say that most oil and gas observers don't see how to reconcile these two cases and just view them as inconsistent. But I think there is potentially ways that you could reconcile this. So one thing here is this is not saying okay. It's not specifically stripping all those rights away from a 1/16 mineral interest. It doesn't explicitly do that like we had in the French versus Chevron case. And it also does, basically says this is just a royalty. So it seems more like that in and under language was kind of, a mistake rather than, because what was really intended to be described was a royalty rather than a deliberate process of describing a mineral interest and then taking away everything but the royalty. Frankly, the other thing that really may be going on here is that remember that probably the most common interest somebody would retain is a 1/2 of lease royalty, right? And for many years, the standard lease royalty was 1/8, right? So 1/2 of 1/8 is what? 1/16. So it's possible that there's an intuition here that 1/16 of production, that 1/16 royalty would be a very common thing for a grantor to reserve from a sale. And so we're just going to interpret that as 1/16 here. But it's important to understand these cases, a lot of people find them hard to distinguish. Okay. Some other questions about whether can you customize a royalty. So think about this. What if you had a deed that granted a 1/16 royalty on oil and gas, and then it said there's the right of ingress and egress? Does that mean that the parties intended to grant a mineral interest? I mean, it sounds like a royalty, but then they're giving you the right to go on the land, which doesn't normally come with a royalty. So does that mean that really, although they use the language for royalty, they intended a mineral interest? Well, it depends on whether the court thinks royalty has the same well-understood meaning. In Texas, they're generally going to allow you to customize. They'll say, yeah, no, that's still a royalty, but maybe you just wanted to give the landowner, the royalty interest holder, the right to go onto the land to check production, to verify for themselves that they're getting their full share, or to take that royalty in kind. Okay. Another customization case, this one from Oklahoma, 1987, described on page 456 in your book, Anderson versus Mayberry. In this case, the terms of the writing are accepting and reserving onto the grantors an undivided 1/2 interest in and to all of the oil, gas, and other minerals in, under, and that may be produced from said property, and the said interest so reserved shall be non-participating in bonus and rental rights. Okay, so first, what is this? Is this a mineral interest or is this a royalty? I think what you'll see here, in and under, this is a mineral interest, right? By the way, a 1/2 royalty would be huge. So we generally wouldn't think it would be a 1/2 royalty. This is a 1/2 mineral interest. It does say, though, that you don't receive the bonus and delay rentals. Okay, so the question here is, does the owner of this 1/2 mineral interest have the right to lease their 1/2 mineral interest? And the court determines that no, because they don't receive the bonus and they don't receive the delay rentals, we don't want them negotiating a lease, because if they did, they'd be negotiating a bonus and delay rentals like normal, but not for themselves, because they're not going to receive that bonus and delay rental. And so the court says you implicitly waived that right to execute leases by expressly taking a right that was non-participating. And so we'll see that basically, effectively, they gave up the executive right here, which is something that we'll talk about in those future cases. But they do say, you still, because you have that 1/2 interest in the minerals, you're of course going to get 1/2 of the lease royalty. Here, the lease royalty was 3/16, so you're going to get 3/32 of production.